what happens when the very institutions designed to be open, to be public, the bedrock of our justice system, what happens when they start operating behind closed doors?
That's a huge question. It really cuts to the core.
Yeah, it strikes right at the heart of our democracy, I think, and it's precisely what we're diving into today. Welcome to the deep dive. Today, we're peeling back the layers on judicial transparency and the rule of law.
And we've got some great material to work with.
We do. We're drawing insights from a really significant 2015 forum hosted by the Pound Civil Justice Institute. It brought together, an incredible array of judges, legal scholars, practicing attorneys.
A real powerhouse group.
Absolutely. And our main sources are fascinating papers from Professor Judith Resnick at Yale Law School and Professor Nancy S. Marder from IIT Chicago-Kent College of Law. Plus, we have some powerful comments from U.S. Supreme Court correspondent Adam Liptak and other legal experts, too.
Right. Top minds looking at this.
So our mission today is pretty clear. We want to explore this undeniable shift towards non-public ways of resolving disputes. We want to look at its impact on our democratic practices and maybe how courts are trying to stay relevant, stay accessible in this, super fast-paced digital age.
That's a big challenge for them.
It really is. And you might be surprised by some of what we uncover about how justice is being served or perhaps isn't out in the open.
Yeah, let's start with that idea of open courts. It's a crucial starting point because historically, courts were fundamentally public.
Right.
You go way back, it was about monarchs showing their power. Then in democracies, it shifted to protecting the public's right to actually observe, to use the courts, to seek remedies. This public aspect has always been key.
And that principle seems so straightforward. I remember reading Jeremy Bentham, the philosopher, saying something like, publicity is the very soul of justice.
That's the quote. Powerful, isn't it?
It is. It's meant to be the heartbeat of open courts, ensuring fairness, accountability, all that. But you mentioned earlier this idea of it quietly eroding. What's actually undermining this core idea?
Indeed. Professor Resnick uses a really telling term for it, dispute diffusion.
Dispute diffusion, okay.
Yeah. And it's not just a small trend. She argues it's more like a quiet revolution, where traditional courts are actively being, sidelined. Their unique constitutional role is getting sort of watered down by these new, often private ways of handling things.
How so?
We're seeing alternative dispute resolution, ADR, things like mediation and arbitration presented almost as interchangeable options, just items on a menu, a dispute resolution spectrum.
So courts become just another choice on the menu.
Exactly. They sometimes even get rebranded as judicial dispute resolution or JDR. And in that framing, they kind of lose that special identity, that constitutional standing.
That's a strong claim, courts losing their unique constitutional identity. What does that really mean for, say, the average person? Beyond the legal theory, what's the impact if a court is just another option?
Well, fundamentally, it means less public scrutiny, less accountability. And this whole shift, it's being pushed along by a couple of things. New mandates telling judges they have to promote settlement, push people towards deals, and critically, the U.S. Supreme Court's really broad enforcement of the Federal Arbitration Act, the FAA.
Ah, the FAA. Okay.
Yeah, these forces work together, kind of redefining how disputes get resolved, and often pushing them right out of the public view.
And the Supreme Court's role here sounds pretty central to this privatization trend.
Oh, absolutely.
The FAA, wasn't that originally for something else, like back in 1925 for businesses arguing?
Exactly. It was designed for commercial disputes between merchants. But the court, especially since around 2002, has dramatically expanded its reach and scope.
So it applies more broadly now.
Much more broadly.
Yeah.
To consumers, employees, even people injured in accidents, tort victims. It covers a huge range now.
What's the court's reasoning for doing that, for applying it so widely?
Well, the court's rationale, generally speaking, is that arbitration is supposedly cheaper, faster, end quote, an effective means of vindicating rights. That's the phrase they often use.
An effective means. But does it always work out that way?
That's the million-dollar question, isn't it? This broad application has had some really profound consequences. Take the 2011 case, AT&T Mobility versus Conception.
I remember that one.
Huge case. That decision basically gave the green light to class action bans in arbitration agreements.
So no more joining together with other people who have the same small problem?
Pretty much. That single decision, it didn't just allow class action bans. Critics argue it effectively created an access to justice desert for countless consumers.
Yeah.
If your individual claim is too small to pursue on its own, maybe just a few $100s.
Right, not worth hiring a lawyer for.
Exactly. And you can't join a class action. You often have no practical way to hold a large company accountable, no recourse at all.
That's a powerful point, and it brings up something else. These arbitration clauses, the stuff you find in the fine print,
Yeah.
the boilerplate language you click agree to for your phone or credit card, are they really contracts in the traditional sense? If there's no real negotiation, no meaningful consent, Professor Resnick argues they're more like products or things just sort of handed to us.
She makes a really compelling case there. I mean, is it truly consent when it's buried in page 37 of terms you can't possibly read?
Right.
And the data seems to back her up. Look at the Consumer Financial Protection Bureau, the CFPB. They did a study.
Okay, what did they find?
They found a startlingly small number of actual consumer arbitrations. In the credit card market, over 3 years, just 616 individual arbitrations. And get this many, were started by the companies themselves, not the consumers.
Wow, 616. That's tiny compared to the number of credit cards out there.
Exactly. So as Professor Resnick suggests, this data doesn't really show effective vindication of rights. It looks more like, well, no vindication at all for most people.
No vindication. That's stark. And it's not just about, cell phone plans or credit cards, is it?
Not at all.
People sometimes have to sign these things for really essential services, even medical stuff.
That's the reality for some, unfortunately. We hear about cases where people needed, say, a knee replacement or even emergency eye surgery, and they had to sign an arbitration agreement as part of the intake process.
So wait, if I need critical medical care, I might have to sign away my right to go to court if something goes wrong.
That's the situation some people face. It really highlights a stark shift in the power dynamic, doesn't it? Where getting essential services might depend on you giving up your access to the traditional court system.
Wow. Okay, this quiet erosion, this shift to private arbitration, it naturally leads us to think about the consequences. Specifically, the hidden costs of all this secrecy.
Precisely.
When disputes move out of the public eye, it's not just the people involved who might lose out. We often see judges signing off on secret settlements, protective orders, keeping crucial details locked away.
That happens all the time. As one expert at the forum put it, the public often knows maybe 1% of what is going on in that courtroom.
Only 1%.
Because so much happens during discovery, that vital information gathering phase, and it often happens behind the curtain, shielded by these protective orders. This secrecy essentially privatizes the litigation itself.
And denies the public access to details that could be really important, right, for public health, safety.
Exactly. It makes you wonder then, how many injustices or dangerous products just keep causing harm because that critical information never actually sees the light of day?
Well, what's the broader societal cost there? If information about, say, a faulty product or corporate wrongdoing is hidden in a secret settlement?
The cost can be immense. Think about it. If defects in a car model, or side effects of a drug, or widespread discrimination in a company are all settled secretly, case by case,
Then nobody connects the dots.
right, that crucial information never reaches the wider public or regulators. It prevents others from being warned, stops them from taking action, and obscures systemic risks. It's a huge loss for public knowledge and safety.
The real-world impact gets really clear when you look at specific examples, like the Remington rifle case you mentioned.
Yes, the story of Rich Barber. His wife accidentally killed their young son due to what they believe was a defect in a Remington rifle.
That's heartbreaking.
Absolutely devastating. And when they pursued the case, there was a secrecy order. But they challenged it. And by challenging that secrecy, they helped bring critical public safety information about that rifle defect to light, information that could affect thousands of other gun owners.
So challenging the secrecy made a real difference.
A huge difference. Or think about the Bill Cosby case. Portions of his deposition in a civil lawsuit were sealed, kept secret for 9 years.
9 years. Wow.
But eventually, due to a motion for sanctions, basically a formal request for penalties against him and his status as a public figure, those parts were unsealed.
And what did they show?
They revealed really damaging admissions he had made under oath, admissions that have been hidden not just from the public, but potentially from other women who might have had claims against him.
So these examples really drive home how public access through open court proceedings can uncover vital stuff that would otherwise stay hidden, affecting safety, accountability.
Absolutely. It underscores the public stake in open justice.
Now, Professor Resnick used that term junk justice. Can you unpack that a bit more? What does she mean by junk justice?
Junk justice, is her term for processes that lack that essential public access and meaningful judicial oversight. Processes where the outcomes might be fundamentally unfair precisely because they're hidden or rushed.
Can you give an example?
Sure, two really stark examples came up. One was a study of Maryland courts looking at about 4,400 lawsuits filed by debt buyers.
Debt buyers, companies that buy old debt cheap.
Exactly. And they sue people, often for small amounts. The study found that many debtors, often without lawyers, simply defaulted. They lost without ever having a real trial, without legal representation, and sometimes with very little judicial oversight. The system just processed them.
Like an assembly line, not a justice system.
That's the concern. And the other example, which got a lot of attention, was Ferguson, Missouri.
Yes, the DOJ report.
Right. The Department of Justice's 2015 report on Ferguson's municipal court was scathing. It detailed how that court seemed focused on maximizing revenue, basically, generating money for the city through procedures the DOJ called constitutionally deficient.
And that disproportionately hurt African Americans, right?
Massively so. But here's the crucial, almost ironic point. The reason we know about these failures in Ferguson, the reason we could even investigate them, is because courts, even flawed ones, generally have legal obligations to maintain public records and allow public observation.
So the transparency, even if imperfect, allowed the problems to be exposed.
Exactly. That very openness, mandated by law, created the pathway to uncover and hopefully correct those deep injustices. It shows why transparency itself is so vital.
To really get a sense of how far some of these privatization efforts can go, let's talk about Delaware. They tried something called the Marketing Judges Program. Sounds unusual.
It was definitely unusual. It was a legislative attempt by Delaware to keep its edge, its preeminence, in handling big corporate disputes.
Delaware is where a lot of companies are incorporated, right?
Exactly. So they created a system offering confidential arbitration. But here's the twist. It was run by actual Chancery Court judges sitting in their official courthouses.
Judges doing private arbitration.
Yes, but under very specific and, frankly, troubling conditions. To qualify, at least one party had to be incorporated in Delaware. The dispute had to involve at least $1 million.
Okay, so high stakes.
Very high stakes. And the parties had to pay hefty fees. $12,000 just to file, plus $6,000 per day for the judge's time.
Wow. And the crucial part?
No public access.
Yeah.
Zero. It was completely confidential, even though it was happening at a public courthouse with public judges.
So basically, justice for hire behind closed doors. What happened with it? Did it fly?
No, it got challenged. And ultimately, the Third Circuit Court of Appeals, that's one of the federal appeals courts, found it unconstitutional.
Then on what grounds?
They ruled it violated the public's First Amendment right to observe court proceedings, especially those held in a public courthouse by public officials. It's a really powerful reminder that public access is fundamental, even when states try to, let's say, innovate for economic advantage.
Okay, so we've seen the push towards privatization, the dangers of secrecy, with all these challenges swirling around. What does this mean for courts here in the 21st century? They're facing this huge task, aren't they? Balancing tradition with all the crazy, fast changes in technology and communication.
It's a monumental task, absolutely. And this is where Professor Nancy Marder's ideas really come into play. She talks about incremental updating.
Incremental updating.
Yeah, the idea is that courts should take small but continuous steps to improve their public outreach, their education efforts.
Yeah.
Not huge disruptive changes, but steady progress, guided by some key principles. It's about evolving without losing the core functions of judging.
That makes sense. One area where there's been constant debate is cameras in the courtroom. We see them in lots of state courts, but famously not in the U.S. Supreme Court. What are the main arguments there, the pros and cons?
Well, the big pro is obvious, right?
Yeah?
Cameras let the public actually see what's happening in court without having to physically be there. It potentially reaches a much, much larger audience. And many states have adopted cameras, often quite successfully.
Okay, so what are the downsides, the cons?
The concerns are varied. There's the worry that lawyers might start hamming it up for the camera.
Getting to the audience.
Exactly. Or that witnesses might feel intimidated or less candid knowing they're being broadcast. Some worry judges might preen a bit too.
Mm-hmm.
And there's a more subtle concern. If proceedings are televised, will parties who want privacy be even more likely to choose secret arbitration or settlements? Could it actually reduce the number of public trials and oral arguments?
That's an interesting potential consequence, and Adam Liptak, the Supreme Court correspondent, pointed out a striking contrast, didn't he?
He did. He noted that while lots of other high courts, like in the UK or Canada, actually stream their arguments live.
Our Supreme Court has really resisted cameras.
Famously so. Liptak suggested, perhaps slightly tongue-in-cheek, that they fear clips ending up being mocked on Jon Stewart or similar shows. It really highlights that tension between wanting public access and worrying about maintaining, perceived judicial decorum or control over the narrative.
It certainly does. But courts aren't just relying on cameras or lack thereof.
Yeah.
They are making other kinds of progress, right? Less controversial, maybe.
Yes, absolutely. Beyond the camera debate, there are lots of these incremental updates happening, especially using digital tools and improving basic public outreach.
Like what? What are some examples?
Well, many state courts already have pretty good outreach programs going. Things like Appeals on Wheels, where appellate courts hold sessions at universities or high schools.
Oh, bringing the court to the people.
Exactly. Or judges doing community luncheons, classroom visits, teacher workshops, often coordinated by dedicated public information officers. These are solid, traditional outreach methods. But Professor Martyr also highlights more innovative digital solutions.
Okay, I'm curious. Digital solutions like?
She suggests things like developing anonymized settlement databases. Imagine if magistrate judges, who often handle settlement conferences, could draw on a database of past settlements in similar cases without revealing confidential details, of course.
How would that help?
It could help them advise the current parties more effectively, give them realistic benchmarks, and maybe help ensure fair outcomes. Another area is juror websites.
Juror websites, like for people called for jury duty.
Yeah. Moving beyond just those old, often outdated printed handbooks, creating really effective, user-friendly online resources for prospective jurors, explaining the process better, answering common questions, making that civic duty feel a bit less daunting and more accessible.
That makes a lot of sense. And state court apps, that sounds like a real leap.
It really does.
Yeah.
Building on things like the OYES project, which is that amazing multimedia archive for the U.S. Supreme Court.
Right, with the audio recordings.
Exactly. State court systems are starting to develop their own versions. Think about a Texas state court app where you could easily find case information, listen to audio, or even watch video of oral arguments, read transcripts, all on your phone.
That would be powerful.
And then there's social media. We see state court systems like in Connecticut or Hawaii using platforms like Twitter and Facebook quite actively, not just for one-way announcements, but for actual two-way communication sometimes, engaging with the public, especially maybe the next generation of citizens who live on those platforms.
Okay, but that brings up a really tricky issue, doesn't it? Judges themselves using social media. That must be an ethical minefield.
Oh, it absolutely is. A huge minefield. Judges have really significant concerns, and rightly so. They worry about ethics rules, about creating perceptions of bias.
Like, can a judge friend a lawyer who might appear before them?
Exactly. Or what about making political comments, even subtly, or commenting publicly, even indirectly, on cases or legal issues?
Yeah.
It's incredibly difficult terrain.
And there's a big difference between the court having an official Facebook page versus a judge having a personal one, right?
Right. A crucial distinction. The risks with personal pages are much higher. There was actually a case where a judge was removed from the bench partly for using his personal Facebook page to market guns while also referring to himself as a judge.
Oh, wow. Okay.
So these platforms require incredibly careful navigation by judges to uphold impartiality and maintain that vital public trust. It's tough.
So let's try to pull all these threads together. We've talked about the history, the privatization, the secrecy, the technology. Bringing it all back, why is judicial transparency just so vital? Why is it non-negotiable for, the health of our democracy?
Fundamentally, it boils down to this: judicial transparency, openness. They are absolutely central to some of the core principles of democracy. That came through loud and clear from the experts. There's a broad consensus that the court's ability to actually uncover injustice, like we saw in Ferguson, for instance, stems directly from their legal obligations. Obligations to keep public records, to allow people to observe proceedings. That very openness is what creates the potential, the pathways to correct injustice and hold power accountable. It builds public trust.
And it's not just about the courts wanting us to like them better, is it? Adam Liptak made a great point about the public having its own stake in this.
He really did. Liptak emphasized that transparency isn't just about the court's self-interest in being understood or seen as legitimate. The public has an independent interest, a right even, to monitor what its government is doing, and the judiciary is a branch of government.
So we have a right to watch.
Essentially, yes, to ensure it's functioning properly, fairly, according to the law. That oversight is just a cornerstone of democratic governance. We can't oversee what we can't see.
And we often focus a lot on the Supreme Court or federal courts, but state courts are doing so much of the heavy lifting, aren't they? It feels like they're the real workhorses of the system.
They absolutely are. We can't forget that. State courts have the principal role in administering justice in the U.S. They carry by far the heaviest of our judicial workloads.
Most people's interaction with the justice system is probably at the state level.
Exactly. And while, yes, Supreme Court rulings on arbitration have maybe reduced their power in some areas, state laws and state courts are still crucial. They determine if a contract is even valid in the first place. They handle the vast majority of civil and criminal cases. So their transparency, or lack thereof, directly impacts most people's lives and their ability to seek justice.
So looking ahead, if courts don't manage to adapt, if they don't find that really delicate balance between necessary public access and, legitimate needs for confidentiality in some cases, what's really at stake for them, for their future?
The stakes are incredibly high. I mean, some experts argue that if courts don't keep up, if they don't remain accessible and transparent in ways the public understands and values, they risk just falling behind, becoming irrelevant.
Irrelevant, that sounds serious.
It is. It potentially impacts their very survival, you could say, in terms of getting public funding, getting legislative support. If the public doesn't see the value, why support it? It's a stark choice they face.
It's interesting to compare this to other places, too. You mentioned Europe.
Yeah, it's a useful contrast. In Europe, generally, consumer arbitration is viewed more as augmenting access to justice, not precluding it. It's seen as maybe another doorway to get a claim heard, but not usually as a barrier that stops you from ever getting to a regular court if you need to.
So an addition, not a replacement?
Kind of. It highlights a different philosophical approach, perhaps, to balancing efficiency with fundamental access rights.
Okay. So we've journeyed pretty deep today into this complex tension between that historical ideal of open courts and the very modern trend towards private dispute resolution. We've looked at the very real costs of secrecy and also some of the innovative ways courts are trying, maybe struggling, to adapt to the digital age while navigating all these new ethical questions.
Yeah, it's a lot to grapple with.
It really is. And it seems clear that judicial transparency is crucial for public trust, for accountability, and that when it erodes, it can really undermine democratic principles. But here's something to think about as we wrap up.
Right.
We live in an era where instant information is king, right? But also where privacy concerns are huge. So how much personal information are we, as a society, truly willing to make public in the name of a fully transparent justice system, especially when you think about sensitive civil cases, family law, and where do you personally draw the line when the choice might be between a potentially faster, definitely private resolution versus a potentially slower but fully public one in open court?
That's the tough balancing act, isn't it? Efficiency versus transparency, privacy versus public access. There are no easy answers there.
Definitely something for all of us to mull over.